This is a quiet residential driveway in Texas. Nothing in this footage suggests urgency or danger, yet this ordinary moment is now a central piece of evidence. When the delivery van arrived, the family was home. Tanner Horner remained inside at first, seatbelt fastened, rolling down the window to speak with an adult.
I would like to speak on the one of the adults, please. There's a Christmas time precaution.
All right, so you can see the kids are playing in the back, and Mr. Horner still has his seatbelt fastened, does he not?
Yes,
He rolls down his window and he asks to speak to one of the adults, correct?
yes,
And tells you that, or says that it's a Christmas time precaution, right?
yes.
Oh, okay.
All right, so he stayed in the van until it appears that he had received some indication that it was okay to get out of the van, right?
What it looks like, yes.
Okay, I was making sure, Kevin.
Now, Mr. Huffman, I'm going to stop for a moment. Can I approach the screen now?
Yes, ma'am.
Mr. Huffman, I have one question. Who is this in the white right here in the background? I assume this is your daughter right here.
That's that's my youngest daughter in the Ford, closer
And
one.
in the background, is that your wife?
To be honest, I can't tell from here.
You need to walk around and look at it.
I may have to.
You know what, I'll play it and I'll get us to a better spot. And the person in the background goes into the house.
Okay, that is my wife
So-
there, in front of the door.
Okay, so when Mr. Horner arrived, your wife was outside as well.
Yes, we both came out.
When he got out of the truck, he told your wife or told people that were outside that, you know, it was a Christmas time precaution because he had accidentally spoiled a kid's Christmas the other day. Is that what he had said?
I believe that's the gist of it, yeah.
He explained his presence as a Christmas time precaution. It was a familiar, relatable excuse that fit the holiday season. There was no perceived threat. The witness described Horner as polite, courteous, and professional. They even exchanged small talk about the holiday rush and the 100+ stops Horner had left for the day.
Now, Mr. Huffman, during this time that Mr. Horner is getting the package out and delivering it to the front, you didn't have any concerns for your safety, did you?
No,
You didn't have any concerns for the safety of your wife?
not at that.
Didn't have any concerns for the safety of your children?
No,
In fact, Mr. Horner was behaving like your typical delivery driver, correct?
well, I would say a little better than the prior one.
A little better than the prior
Yes.
delivery driver? But he was polite,
Yes,
and he was courteous, and he engaged in small talk with you and your family,
right.
but nothing that would give you pause.
No, ma'am.
Nothing that would make you get on your dispatcher and call the sheriff,
No,
and nothing that would make you call dispatch.
no.
All right, so Mr. Horner had just 115 stops today. Did you hear that?
I didn't catch it, I'm sorry.
Okay. So Mr. Warner did say that there were 115 stops that day, not too bad. And during this time period, you can see yourself walking back out of the house,
Yes, ma'am.
and you're walking towards the back of the truck,
Correct?
and Mr. Warner's putting on a seatbelt.
Yes.
Oh, man. You have to tell them. Oh, Merry Christmas.
Mr. Huffman, the only other question I had about the package was the package clearly marked what the contents were?
But the significance of this footage is the timeline. Within 24 hours of this polite interaction, Tanner Horner would kidnap and murder 7-year-old Athena Strand. In court, the prosecution asked if the witness's reaction would have changed with hindsight. The defense objected, and the court sustained it.
You would agree with me that there was the possibility that if it had been a surprise, that surprise could have been spoiled?
If it had been, I think so, but it wasn't.
Your Honor, has a witness.
Redirect.
Within 24 hours of that video, Athena's been kidnapped and murdered, correct?
Yes, sir.
Let me ask you, Ms. Anderson, ask you if you felt the need to call the police or dispatch, and he was there 24 hours before. Is that correct?
That's correct.
Now, knowing what you know now, that 24 hours later, he kidnapped and murdered a child the same age as yours, would you still have that feeling with him being on your property at this time?
Well, no.
And what would you do in response?
Objection, Your Honor, that calls for speculation.
Sustain.
Nothing further on.
Redirect. Ms. Anderson.
Yes, but at the time, you didn't fear for your safety.
At the time, I did not.
You did not fear for the safety of your girls.
No.
You did not fear for the safety of anybody in your household.
No.
Nothing further.
Mr. Stank.
Nothing, Your Honor. Thank you.
May this witness be used subject to any potential recall?
No objections.
Okay. Thank you very much. All right, I hate to do this, but we've been working, so.
With guilt already established, the focus shifted from the driveway to the finality of the courtroom. The jury was tasked with two specific issues: whether Horner remained a future threat, and whether any mitigating circumstances justified life over death.
Moral culpability of the defendant. There is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer: we, the jury, unanimously find that the answer to special issue number 2 is no. Signed by the presiding juror. Does either side desire a poll?
No, Your Honor.
No, Your Honor.
Ms. Anderson, Mr. Goebel, is there any legal reason why a sentence should not be pronounced?
No, Your Honor.
Mr. Horner, if you'd stand, please. It's the order of the court that you, Tanner Lynn Horner, has been adjudged to be guilty of the offense of capital murder as found by the jury. Jury having answered the special issues, making it mandatory that your punishment be death, it is therefore the order of this court that your punishment be death. Before the hour of sunrise on a date to be determined by this court, upon a mandate of affirmance issued by
The transition from the routine to the terminal was absolute. The jury found Horner to be a continuing threat with no sufficient mitigation. As the courtroom fell still, the judge pronounced the legal consequence.
find that the answer to special issue number 2 is no. Signed by the presiding juror. Does either side desire a poll?
No, Your Honor.
No, Your Honor.
Ms. Anderson, Mr. Goebel, is there any legal reason why a sentence should not be pronounced?
No, Your Honor.
Mr. Horner, if you'd stand, please. It's the order of the court that you, Tanner Lynn Horner, has been adjudged to be guilty of the offense of capital murder as found by the jury.
Tanner Horner was sentenced to death.
Answered the special issues making it mandatory that your punishment be death. It is therefore the order of this court that your punishment be death. Before the hour of sunrise on a date to be determined by this court, upon a mandate of affirmance issued by the Texas Court of Criminal Appeals at the State Penitentiary in Huntsville, Texas, you will be caused to die in accordance with the rules and regulations established by the Texas Department of Criminal Justice until you, said Tanner Horner, are dead. Said execution procedure shall be determined and supervised by the Director of the Texas Department of Criminal Justice. The clerk of this court shall issue a death warrant in accordance with this sentence directed to the Director of the Texas Department of Criminal Justice for that purpose. Clerk shall deliver such warrant to the Sheriff of this county and to be by him delivered to the Director of the Department of Criminal Justice together with you, and you will remand to the custody of the Tarrant County Jail to await transportation to the Texas Department of Criminal Justice at Huntsville, Texas, and the execution of this sentence. I will sign this death sentence as required by law. Your appeal of the finding of this guilt by the jury and their determination of the answers to the question in this sentence are automatically appealed to the Texas Court of Criminal Appeals in Austin, Texas. You will be appointed a lawyer to represent you on direct appeal, and your lawyer will receive a copy of the record of this charge, of this case at no charge. You have the right to have a second lawyer to represent you on writs of habeas corpus. It's a separate matter from your direct appeal. Do you wish to have counsel appointed for your writ purposes?
Yes, sir.
Okay, then I will appoint you writ lawyers for that. Ms. Anderson, Mr. Goebel, if you will remain on his case pending his decision, and we have all the appellate paperwork filled out, I have received his acknowledgement certification of the right to appeal, and I appreciate you doing that. You may be seated. Is there an allocution?
The polite driver in the driveway was replaced by a man facing the ultimate penalty of the law. This is the evidence showing how the ordinary became a tragedy.